Is it an illegal sentence if a defendant waives his right to apply for the shock treatment program while incarcerated? To find out, you have to read People versus Santos, but it's 16 pages. Don't have time for that? I've got you covered. This is TLDR, Too Long Didn't Read, where I cover New York Court of Appeals cases and I try to do it in 5 minutes or less. This is the episode on the case of People versus Silva Santos. The citation for this case is 2025, New York Sub-Opinion 01008, published by the New York Court of Appeals on February 20th of 2025. The issue in this case is whether a defendant, as part of a plea, as part of an agreed-upon plea with the prosecution, is allowed to waive even applying to the shock incarceration program through the Department of Corrections. To understand and appreciate the context of this case, what you have to know is that shock program is like a 6-month boot camp that, depending on what you've pled guilty to, you could be eligible or you could not be eligible to apply to it. But if you apply to the shock program, it's sort of like a boot camp that lasts 6 months, where it involves intensive treatment and therapy and physical exercise and regimented schedule. And if you complete this program, you get to get out of jail like 2.5 years earlier than your scheduled release date. But it takes 6 months, and it's very difficult, and it's very intensive. And theoretically, it has a much better rehabilitative result than just being released from jail in general. If you graduate from the shock program, statistics say you are 52% less likely to be a recidivist, to commit a new crime that will land you back in jail in the next 3 years after your release. Now, until 2009, only docs decided who participated in shocks. You could apply as an inmate to shock. If they accepted you, you'd do the shock program. But in 2009, as part of the drug reform law, they added a second way that you can get to do shock. One was docs still, and the other way was a judge could order that you participate in shock. So you could say, I want to be in shock, and the judge could say, I'm ordering shock for this defendant as part of the disposition. Now, the facts in this case, the question in this case is not when a judge orders the defendant to participate in shock. The question is, can a judge basically order the defendant not to participate in shock? The facts in this case is the defendant was charged with 2 counts of operating as a major trafficker of drugs. He was allegedly found with over 50 pounds of heroin and fentanyl, which is like, drug kingpin amounts of drugs, which would be an A1 drug felony. And under that felony, if he was convicted of it, he would be ineligible to participate in the shock program. But the prosecution offered the defendant a plea bargain, offered him to plead guilty to a B drug felony, criminal possession of a controlled substance in the 3rd degree, a B drug felony. But part of the condition of their plea was you are waiving your right to seek shock treatment, to seek that shock program. You're not allowed to apply to docs for shock. The defendant agreed to this plea, 9 years instead of much more, if he was convicted of the A1 drug felony. But at sentencing, when it's time for sentencing, the defendant asked the judge at sentencing. He was remorseful. He expressed his remorse. He said he had a drug or alcohol problem. He said his child had issues. And he said to the judge, I'd like to participate in the shock program or something similar. And the judge said, no, unfortunately, I can't. Part of the plea is you said you waived it as part of your plea. I'm not allowed to. The judge then signed the sentence and commit, including the jail he agreed to, and that the defendant waived his right to shock. The defendant then appealed his conviction. He appealed the sentence and said it's an illegal sentence because the judge was denying me my ability to apply through docs. Yeah, I'm not applying through the judge, but I have a right under the statute to apply through docs, and they're making me waive that right. And that's an illegal sentence, according to the defendant. The Appellate Division, First Department, disagreed and affirmed the conviction, affirmed the sentence as valid, and he appeals to the Court of Appeals. And here, the holding here is we have a 5-2 split. We have a split decision here. The majority says it's not a part of the sentence at all. It's not a legal sentence because it's not part of the sentence. The sentence was the 9 years he agreed to, the 9 years jail. They say if it does not impose a particular form of punishment or prohibit docs from calculating the defendant's sentence in a particular manner, the time, the actual calendar time, that's what a sentence is. This particular provision, this condition, does not affect the amount of time he's in jail or prohibit docs from calculating the defendant's sentence. That's not what it does. So it's not a part of the sentence. It's different. That's the majority's decision. So it denies it because it's not part of the sentence. But the dissent here by Judge Wilson, joined by Judge Rivera, is they reform the question completely. They say they don't say is this part of the sentence. They say, is the waiver of a shock in a plea agreement against public policy? Because the defendant's not allowed to waive everything in the whole world as part of a plea. The defendant can't say, well, I'm waiving the right for you to treat me if I get sick in jail, or I'm waiving the right to be tried by 12 human beings, or I'm waiving rec time, or I'm waiving sleep. There are certain things that are void as against public policy. And under that analysis, the dissent would say it's against public policy to deprive a defendant who's incarcerated of the ability to participate in shock because it helps everybody. It saves money for the taxpayer. It's more rehabilitative. It's less recidivism. And as that analysis goes, this would be void as against public policy. They would strip out the waiver part of the sentence. But once again, the majority here is it's not a violation. It's not a legal sentence because it's not even part of the sentence. And that's the case of People versus Santos. Have a good day. If you like what you just saw and want to see more just like it, please hit like or subscribe to let me know.